This video lecture will focus on end-of-life issues, and in particular, the legal and ethical issues surrounding advance directives. There is much focus on treatment decisions in the behavioral health care arena, but controversies in the medical community primarily surround not treating somebody, or rather withholding treatment. It's not controversial when someone says, "I'd like to have that treatment," or that surgery. Rather, when someone says, "I don't want to have any treatment done," or when someone says for them, "You should not treat that person," that's where more controversy arises. There are a number of contextual issues that are involved in the treatment decision-making process. For example, there are autonomy issues. Our society greatly values individual autonomy, particularly over control of what happens to one's own body. There are also mental capacity issues. The mental capacity or competence of the individual is critical in the treatment decision-making process. There are also surrogate or proxy decision-maker issues. Laws governing surrogate and proxy decision makers can determine the course of care. A surrogate decision maker is someone who is appointed by the person themselves to make the decision on their behalf, whereas a proxy decision maker is someone who is appointed by the court to make decisions for another person. Finally, there are state interests that are involved. State interests such as preserving life and state interests in fairness come into play when the treatment decision-making process is focused on. A seminal U.S. Supreme Court case in the area of treatment decision-making is Cruzan versus the Missouri Department of Health. This is a 1990 case, so it didn't happen that long ago, only a little over 25 years. Nancy Cruzan was in her 20s and was involved in a tragic auto accident. Shortly after the accident, she was placed in a long-term care facility owned by the state of Missouri, and that's why this case is her family, Cruzan, versus the Missouri Department of Health. She was in a persistent vegetative state, or PVS, and kept alive by feeding and hydration tubes. A persistent vegetative state is where the person, while technically alive with a beating heart, requires external assistance to stay alive. Nancy Cruzan could not keep herself alive because she was unconscious. After several years in the facility, her parents asked for the feeding tubes to be removed, thus letting her to die. The physicians and hospital refused, stating that Missouri public policy was to preserve life, and that policy could only be overcome by clear and convincing evidence. Thus, the burden of proof was the middle level of proof, clear and convincing evidence. The Supreme Court eventually denied the Cruzan family's request to remove the feeding tubes, but made several important findings in the process. First, they found that the 14th Amendment protects a competent person's right to make treatment decisions. Thus, when you or I or anyone else in our class makes a competent treatment decision, that must be respected, and it is a right protected under the Constitution. Second, if a person's wishes are expressed while competent, then they should be honored when the person becomes incompetent. This essentially validated advance directives, which are typically documents that indicate what a person wants done when they cannot make decisions themselves. Finally, the Supreme Court found that the state can set the level of proof of those wishes at clear and convincing evidence. And since the Cruzans did not have evidence at that level at that time, they rejected the Cruzans' appeal. Now, the family ultimately convinced the Missouri courts that they indeed did have clear and convincing evidence that Nancy would not want feeding tubes. She was then taken off the tubes and allowed to die. So let's take a look at the implications of Cruzan. With regards to treatment decisions of competent individuals, under Cruzan, if a person is mentally and physically capable, that is, competent, to make a voluntary, informed treatment decision, the 14th Amendment protects the person's right to make any treatment decision. So the issue becomes here, what is competent? Under Florida law, competence for treatment decisions is defined in the Healthcare Advance Directive section of the Florida statutes. And that is what we discussed with regards to being competent to provide informed consent. Incapacity or incompetent means the patient is physically or mentally unable to communicate a willful and knowing healthcare decision. And for the purposes of making an anatomical gift, the term also includes a patient who is deceased. So as I said before, this is a very subjective definition, and it is not unusual across the country. Many states have definitions like this. In an earlier module, we also went over Grisso and Applebaum's more objective approach to determining competence to make treatment decisions. They set out to define components and create a more objective determination of competence by reviewing legal standards across the country and then developing a 4-element model for determining a person's competence to make treatment decisions. You can check your notes from Module 4 about this approach, but in brief, the Grisso and Applebaum approach requires the assessment of 4 elements. The first is the ability to communicate, that is, to provide a consistent choice with regards to treatment. The second is the ability to understand relevant information, and this element can be remediated through assistance and training. The third element is the ability to appreciate the situation and its consequences, which involves being able to apply the information to their own situation. And finally, the fourth element is the ability to manipulate information rationally. That is, do they possess logical processes to manipulate information and weigh the risks and benefits of the treatment offered? Regardless of how competence is defined, the determination should be documented in the person's medical record. Now, even if a person is considered competent to make a treatment decision, their decision can still be overruled in certain circumstances. Courts have described 5 compelling societal or state interests that may override a patient's wishes in a particular situation. The first is preventing suicide. Our society does not accept that a person can end their life in all circumstances. Some states have made exceptions to this public policy in certain narrow circumstances, such as at the end of life when they allow physician-assisted suicide. But in general, suicide is not accepted. The second compelling state interest is that of preserving life. This is almost a universal societal interest, and it's the foundation of most governments across the world. Where this gets debated is usually around what is life, or when does life begin? The third compelling state interest is the protection of innocent third parties. This typically comes into play when parents are making decisions for their minor or dependent children. Parents may make medical decisions that are counter to what the hospital or physicians believe is best for the child, and they may challenge the decision. For example, there are religious communities that do not believe certain kinds or any modern medical approaches are appropriate to implement. The courts have overruled parents' authority in some of these cases where parents have refused treatment for the child on religious grounds. The fourth compelling state interest is maintaining the ethical integrity of health professions. Health professionals should not be required to do things that they feel are inappropriate or unethical, and the society will typically back them up on it. The final compelling state interest is that of maintaining institutional order. This usually happens in places such as schools or prisons where order is necessary in order to function. For example, if a prisoner decides to go on a hunger strike, the state or prison can ultimately force him to eat, and thus override his decision to hurt himself. This action could be considered necessary to maintain the order in the facility. The number of times that societal interests override competent decisions is very small. In general, if a person is competent, they can make decisions about their health care, and those decisions will be honored. The Cruzan case makes the ability to make those decisions a right under the Constitution. So how are treatment decisions made when the person is incompetent? What I'd first like to do is address this issue when there is no advance directive. That is, when a person did not execute a valid advance directive indicating what they would have wanted. So absent an advance directive, what the hospital and courts look to are proxy decision makers. And depending upon the state, a statute would typically describe first who can be the proxy decision maker, and second, what standard the proxy should use to make decisions. Florida has a law that is typical of other states, so let's take a look at Florida. I realize the type is small on this slide, so the Florida statutes that I'll discuss here and in the next several slides are available on Canvas in the reading materials for this module. So section 765.401 of the Florida statutes reads, the proxy, 1. If an incapacitated or developmentally disabled patient has not executed an advance directive or designated a surrogate to execute an advance directive, or the designated or alternate surrogate is no longer available to make healthcare decisions may be made for the patient by any of the following individuals in the following order of priority, if no other individual in a prior class is reasonably available, willing, or competent to act. So first up, the person that would make a decision for you is the judicially appointed guardian, which makes sense because the court has already selected that person to make decisions for the incompetent person. Second in line is the patient's spouse. This also makes sense because the incompetent person trusted the spouse enough to marry him or her, and the spouse has the most stake in the particular situation. Next in line is the majority of the adult children of the incompetent person. So be nice to your children because they could be making a decision about whether you should have feeding tubes or not. Next in line are the parents of the patient. So be nice to your parents because they can be making decisions for you. Next is the majority of the adult siblings of the patient. so be nice to your brothers and sisters. Next is an adult relative of the patient who has exhibited special care. So you never know who might be making decisions about you. It could be your great uncle Buck or your Aunt Gloria. Next in line is a close friend of the patient. I don't know how such a person could be identified, but there it is in the statute. Finally, if no one else is available and the patient has no family or friends, or enemies for that matter, who can help make decisions for them, a clinical social worker at the facility can make the decision for the patient. This social worker provision was added in 2003 because there were some patients who had no one who could make decisions for them. So you can see, it can be very important that you execute an advance directive so that your wishes are carried out the way you would want them to be, and not to have someone else make a decision for you who you don't even know very well. Some of you may be familiar with the Terry Schiavo case from a couple decades ago here in Florida. In that case, Terry Schiavo was in a persistent vegetative state, and her husband ultimately decided that this is not what she would have wanted. Her parents and siblings disagreed and fought the decision by the husband to remove feeding tubes and to allow Terry Schiavo to die. This statute is what came into play. And as you can see, the husband or spouse had a higher priority than the parents or siblings of Terry Schiavo. That case hinged on some other issues as well, as we'll see in just a minute. Section 765.401 goes on to read, any healthcare decision made under this part must be based on the proxy's informed consent and on the decision the proxy reasonably believes the patient would have made under the circumstances. If there is no indication of what the patient would have chosen, the proxy may consider the patient's best interests in deciding what proposed treatments are to be withheld or that treatments currently in effect are to be withdrawn. This section gets to what standard the proxy should use to make any decisions. There are two types of standards in these situations. The first is called substituted judgment. Substituted judgment means that the person making the decision should make that decision based upon how the incompetent person would have made it. In other words, they substitute the incompetent person's wishes over their own. So they decide how the incompetent person would have decided in that situation. The second standard is called best interest. Best interest means that the person making the decision should make that decision based upon what that person believes is in the best interests of the incompetent person, not necessarily what the incompetent person would have wanted. So they are making a decision as they themselves would have decided. As you can see in Section 2 here of the Florida statute, Florida uses a substituted judgment standard that is based on the decision the proxy reasonably believes the patient would have made under the circumstances. The Florida statute goes beyond that, though, and says that if the proxy does not know what the patient would have chosen, then the proxy can decide based upon what they believe is in the patient's best interest. So Florida really has a hybrid standard that kind of combines the two possibilities sequentially. Section 3 reads, before exercising the incapacitated patient's rights to select or decline health care, the proxy must comply with the provisions of two other sections, except that the proxy decision to withhold or withdraw life-prolonging procedures must be supported by clear and convincing evidence that the decision would have been the one the patient would have chosen. So the Florida statute reflects the Cruzan decision, where clear and convincing evidence of the patient's wishes is necessary. This is what caused the controversy in the Schiavo case. It was initially felt that there was not clear and convincing evidence of what Terry Schiavo wanted. But ultimately, her husband provided testimony from friends and others that convinced the judge that indeed she would not have wanted to remain in a persistent vegetative state. So this is the law that courts will look to if you do not have an advance directive in place. So let's consider the situation when advance directives are present. An advance directive is a written document executed by a decisionally capable or competent adult that pertains to the future medical treatment preferences and values of the person. So it's not just what preferences a person has, but also their values, because not all future situations may be recognized by the person. So providing an indication of what his or her values are can help the decision maker make an appropriate decision that is in line with what the patient would have wanted. There are two types of advance directives. The first is instructions. Instructions are for very specific situations and describe precisely what the person wants done. Examples of instructions are living wills or DNR, do not resuscitate orders. These are documents that come into play in a very narrow circumstance and give very specific instructions as to what should be done. The second type of advance directive is a surrogate or appointment. These are also sometimes called healthcare surrogates or durable power of attorneys for healthcare. For these advance directives, power to make decisions is much more broad, and it can involve a variety of situations. So let's discuss each of these in more detail. As I said, examples of instructions in Florida are living wills and do not resuscitate or DNR orders. A living will is essentially an instruction about how you would like to be treated when you are pretty much at the end of your life. You have a terminal illness or terminal condition and there really is no hope for getting any better. In Florida, you must suffer from at least one of three conditions as determined by two physicians. The conditions are a terminal condition, an end-state condition, or a persistent vegetative state. These three types of conditions are specifically defined by the statute, but they are really very similar. And the thing to keep in mind is that the end is near. So you have to have at least one of these conditions, have no reasonable probability of recovery, and have those wishes documented in the medical record. As far as I know, no one has been sued for honoring a living will in Florida, so living wills are very powerful. Let's take a look at what kind of language is contained in a living will. Our legislature in Florida has provided us with a template for a living will. Now this template is also provided in the reading materials for this module, so you can look that up if you'd like to. As you can see, the living will is fairly simple. It's just a declaration that the person is voluntarily making known their desire that their dying not be artificially prolonged. They have space for initialing the three types of conditions that are the requirement for it, although most people just initial all three. And it notes the requirement that there's no reasonable medical probability of recovering from the condition. It further directs that life-prolonging procedures be withheld or withdrawn when they just serve to prolong the process of dying, and that you be permitted to die naturally with only palliative care, which is care to reduce pain. There's a statement about wishing everyone to honor the declaration, as well as language identifying a surrogate who can carry out the wishes if there is some problem. Finally, there's a place for the signature of the person making the declaration, as well as for two witnesses. That's it. So now you have a living will that you could execute. The second type of instruction that I'd like to discuss is a do not resuscitate or DNR order. These are used when a patient does not want extraordinary measures taken to save their life, especially CPR or cardiopulmonary resuscitation. It is an order from the person's physician. DNR orders used to only occur when the patient was in the hospital, but as care has shifted to the community, they are more common outside the facility. Because of this, new rules about the form they must take, as well as the color of the paper they are printed on, were passed in the 2000 legislative session in Florida. An example of such a form is provided in the reading materials for this module. But note, the forms must be printed on canary yellow paper. Otherwise, they are not considered valid, and professionals do not need to honor them. The paper color requirement was put in place so that emergency personnel could identify them immediately when they're in an emergency situation. The second type of advance directive, in addition to the instructions that I just talked about, are surrogates or appointments. In most states, durable powers of attorney for healthcare are commonly used to provide for decision-making when a person is unconscious or incompetent and in need of medical care. You should review your notes from Module 6 when we discuss powers of attorney and durable powers of attorney. The durable power of attorney for healthcare decisions is essentially a springing durable power of attorney that springs into force when a person is unconscious or declared incompetent. The powers in such a document typically include making decisions about the health care of the patient and financial issues surrounding their medical care. In 2011, the Florida legislature specifically invalidated springing durable powers of attorney in Florida. Instead, what they require for healthcare decisions is a Florida healthcare surrogate form. The Florida healthcare surrogate is essentially a springing durable power of attorney for healthcare decisions. I'm not sure why Florida chose to go this route, but it is what it is. So in Florida, instead of a durable power of attorney for healthcare, a resident should execute a Florida healthcare surrogate arrangement. The standard of care stipulated by the legislature for decisions made by a healthcare surrogate is substituted judgment. That is, the person making the decision should make the decision based upon how the incompetent person would have made it. Here's a copy of the Florida Healthcare Surrogate Form or template. I've also provided a copy of it in the reading materials for this module in case you'd like to take a look at it. As you can see, it first designates who the healthcare surrogate is, as well as provides for an alternate healthcare surrogate if the first designee is not available or not willing to perform his or her duties. It then authorizes the healthcare surrogate to not only receive healthcare information, but to also make healthcare decisions for the person, and lists a number of specific powers. The surrogate form goes on to indicate that the person executing it can revoke the surrogate's power to make decisions at any time, and stipulates the process by which that can be done. There is then space for signatures of the person executing it, as well as 2 witnesses. So that's it for the healthcare surrogate form. This document gives power to someone else to make healthcare decisions for a person who cannot make them for themselves in Florida. So there have been a number of recent statutory changes to the Advance Directives law in Florida, and here's a list of some of them. In the 2000 legislative session, they made a number of changes to the DNR order provisions mandating public education, specifying some pain management procedures, and requiring it to be printed on yellow paper. In 2001, they added the best interest provisions to the surrogate forms and to the process when advance directives aren't executed. In 2002, they stipulated how to take the decision-making authority back from a proxy. This is important because the court has essentially given someone else power to make decisions, and the statute never indicated how the person could get the power back from the proxy. Now they know how. In 2003, they added the social worker to the list of who could be a proxy for someone without an advance directive. In 2008, they eliminated the anatomical gift exception on the healthcare surrogate form, so surrogates can initiate the donation of anatomical gifts when someone dies. Finally, in 2015, major changes were made to the healthcare surrogate form and other changes to advance directive provisions. As you can see, this area of the law is constantly evolving. Other important advance directive issues in Florida statutes include the provision that if a family member or physician is concerned about a surrogate or proxy's decisions, he or she can request an expedited judicial review. And the courts work to quickly comply with this law. It's important to be able to get a timely decision from the court when someone's health is involved. A healthcare facility or provider is immune from liability if the healthcare decision is made in accordance with the statute. Thus, if the healthcare provider acts non-negligently, they are immune from liability. If a healthcare provider cannot or refuses to comply with an advance directive, they need to make reasonable efforts to transfer the patient to another healthcare provider. The wishes of the patient are the most important here. Valid out-of-state advance directives are valid in Florida. There is reciprocity among most states to honor directives executed in other states. A surrogate may never provide consent for things like abortions, sterilization, electroshock therapy, and so on. So there are a number of procedures that surrogates have no power to make decisions about. And finally, divorce or annulment automatically revokes a former spouse's designation as a healthcare surrogate. So your ex-spouse can't be making medical or life-prolonging decisions about you. Sounds like good law. I'd like to briefly raise some other end-of-life issues. The first is the Patient Self-Determination Act. This law was passed during the first Bush administration in 1991 and requires Medicare and Medicaid providers to offer information and have policies on advance directives. Because of this act, if you go to a hospital, you'll see pamphlets on advance directives, and staff might even often explain what they are to you. The providers, however, cannot condition treatment on the execution of advance directives, but rather just provide information so that the patient can make their own educated decision about whether to execute an advance directive. There are provisions in the Affordable Care Act, also known as Obamacare, that would provide reimbursement to medical professionals to educate and inform patients about advance directives. Those provisions somehow got twisted into the federal government mandating death panels during the debate about the Affordable Care Act. This was an unfortunate political mischaracterization of what was already being done under the Patient Self-Determination Act. Another end-of-life issue is the dilemma of food and fluids as treatment. The question is, should food be considered treatment, or should it be considered a right? How we characterize it is important, because if it is a right, then we can't take it away from someone who is already on feeding and hydration tubes. Most courts have found that food and feeding tubes are indeed treatment. Therefore, they can be removed if such a decision is made. Another end-of-life issue is medical futility. When should physicians stop treatment? Some argue that when treatment is futile, there is no decision. It should be stopped. So there is no ethical duty to continue it. Another end-of-life issue is the definition of death. Traditionally, a person was considered dead when their heart stopped beating. This sometimes was hard to determine, and thus mistakes were made. For example, an ancestor of mine by the name of Dorcas Burt was found unconscious on the floor of her kitchen. A heartbeat could not be found, and thus she was thought to be dead. Disease was of great concern when someone died, so people back then wanted to bury the dead as quickly as possible. So after a couple hours, they put Dorcas in a wooden box or casket and started walking to the cemetery to bury her. While they were walking with her, she popped up out of the box and almost scared the people carrying the box to death. What had happened was that her heart rate somehow went very low, and she could have possibly been buried alive. This actually was not uncommon back then, and thus people who buried the dead would put a string into the casket box connected to a bell up above the grave. That way, if the person did wake up, they could pull on the string, ringing the bell, and thus be saved from certain death by being buried. This is where the phrase, saved by the bell, comes from. So determining death by whether someone's heart stopped is not a great way to be accurate. Now death is typically determined by brain function cessation, and there is specifically something called the Harvard test of brain functioning to determine whether someone has died. The final end-of-life issue that I'd like to discuss is physician-assisted suicide. Some of you will no doubt be writing about this for your end-of-semester paper, but I'd like to briefly touch on it here. Several states have passed physician-assisted suicide laws, including a number in the Northwest, like Washington and Oregon, and some in the Northeast as well. Early on, though, in the debate about physician-assisted suicide, proponents of assisted suicide fought against state laws banning assisted suicide by claiming that such suicide was a constitutional right. Two 1997 Supreme Court cases, that is Vacco v. Quill and Washington v. Glucksberg, addressed this constitutional issue. The Supreme Court in these cases upheld the validity of state laws making physician-assisted suicide criminal, and they rejected the notion of a constitutional right to assisted suicide. Some have interpreted this to mean that assisted suicide was unconstitutional, but that's just not the case. Rather, it just asserted that states could decide for themselves whether to make assisted suicide legal or not. As I said, several states have already made assisted suicide legal and have set up processes by which it's carried out. Here are some web addresses that might be useful if you want more information about the issues covered in this video lecture, including links to the Florida statutes, to advanced directives guidance by the Florida Agency for Healthcare Administration, and the information on DNRs from the Florida Department of Health. That concludes this video lecture on end-of-life issues and advanced directives.